shall be heard. God save the Commonwealth of Massachusetts. This honorable court is now open. Please be seated.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. It is my great honor and pleasure today to be sitting with Justices Neyman and Justice Smyth, and my name is Gabrielle Wolohojian. We have a list of 3 cases this morning, which means we will not be taking a morning recess. We'll go through the entire list without pause. If your case is partially impounded, and I believe all of them are, we ask that you remember to refer to the parties without using their names. So, for example, father, mother, husband, wife, something like that, that will make it clear, but we won't use people's names. Each side receives 15 minutes to argue. There is no rebuttal in the appellate courts in Massachusetts, so don't reserve time for rebuttal because we don't permit it. The yellow light will go on about a minute and a half from the end of your 15 minutes. The yellow light on the little thing on the podium, the timer on the podium, that's to give you a signal that it's time to begin thinking about how you want to wrap up your argument. When the red light goes on, your argument is over unless we continue to have questions for you. You may structure your argument in any manner you see fit. We want you to tell us what you want. However, you don't need to feel that you have to give us the background. We have read your materials. We have read the appendices. We are prepared for your cases, so you don't need to feel like you need to give us the background. We have these little microphones, but please remember to also keep your voice up, and we'll let you know if we're unable to hear. So with that, I'm going to call the first case, which is case number 2022P 0480. I'm going to use initials here, D.O. versus R.P. And is it Attorney Spallina?
It is, Your Honor. Good morning.
We are ready whenever you are.
Thank you, Your Honor. May it please the Court, my name is William Spallina. I represent, I'll refer to him as the husband in this case. There are no child-related issues in this appeal. The question in this case is one of whether or not a provision in the parties' divorce separation agreement allows the wife to receive half of the proceeds that were recouped in a lawsuit against someone who borrowed money from the husband. And at the outset, I want to first talk about the standard of review a little bit, because I believe we are in agreement, though in roundabout ways. I styled this as an appeal of the contempt because that was the judgment on the action that was brought. It is clear that the issue in dispute is one of interpreting a specific provision in the separation agreement. Counsel for the wife claims that therefore the standard of review, since its contract interpretation is de novo. I would agree with that. I did say that in my standard of review on page 9 at the last sentence of my brief. I suppose the question is one of semantics. You can't file an appeal in the appeals court asking the appeals court to interpret a contract for you. There has to be some vehicle from the lower court to get here. That was a complaint for contempt. There was a judgment. It's unclear if the judgment specifically found my client in contempt. It doesn't appear that that's what the judge said. She simply ordered the husband to pay half of the money that had been collected from a lawsuit against this person that money was owed to. And on that vein, I also want to note, it appears there were, as this court is well aware, 3 contempt cases filed. We appealed the second or the third one, and the reason for that is the first one he was found not in contempt. The second time, as I said, it's the judge seemed to be limiting herself to dealing with whatever money had actually been collected at that time, as opposed to determining what's going to happen in the future, which was good because it was far from clear these people were going to pay back.
Right, so the final order, as I understand it, or final action of the judge, it was in effect a form of clarification because the parties appeared to did not appear to have an agreement, a common understanding of what the future implications of the previous contempt finding were. Is that correct?
That is correct.
Okay. So in that sense, I think we can understand the last order as a clarification of the earlier ruling on the contempt.
And at that point, I would agree, and that's what I thought, and that's why I thought at that point it was appropriate to file the
Right.
appeal.
Okay.
So we're here today.
And so I think we all agree, but tell me if I'm wrong, that really the crux of the issue is the interpretation of that provision in the separation agreement that I think it's subsection G. Maybe we can turn to that. Oh, no. I went straight from numbers to letters. So it's actually section 6.
Yes, section 6 on page 31.
Paragraph 6 of Exhibit G.
Yes. I will get to that, but just to inform the court, since the appeal's been filed, there's been a lot more money that's come in, just so the court is aware of the situation. The settlement agreement with those people who owed the money said if you pay a certain amount by a certain date, you get a discount. That's now been done. They did that. So just so the court is aware, there's $179,000 now sitting there. To be perfectly clear about it, the lawyer who handled that case and collected the money sent a check from a Iolta fund to my client late last year for the $179,000. He has not negotiated that check. He's holding it pending the outcome of this appeal. So now all the money's in, so any concerns about, well, is there money in the future, how much, it's all over.
Is that the end? That's the
the
entire,
end.
okay.
Yes.
So I guess that ties into one question I have about this paragraph 6. Is the money that was received as a result of the settlement, does that encompass all of the properties that are listed in paragraph 6, or is it only one property that was at issue?
It's everything. There's no more coming from any other source
All
to
right.
find it. It was all one person that borrowed this money.
So maybe now you want to turn to the interpretation of the phrase, any after-tax net payment?
Okay. First, I would like to call the court's attention. I'll do that by starting off by calling the court's attention to paragraph 5 right above it, which contains similar language regarding the husband's Mellon stock options. And just so the court knows, he informed me that when he left Mellon, he did exercise his options. He did pay half, as this paragraph requires, to the wife. The net after-tax payment was very simple for a very simple reason. The money that was used to invest in this real estate deal was from the HELOC that the husband got on the house and the wife got on the house. And at the time this agreement was filed, it wasn't clear how much, if any, was ever going to come back. And the understanding was that my client, the husband, is responsible for the payment on the HELOC, and that's in the separation agreement on page 26, paragraph 1B. Commencing May 31st, 2012, shall be solely responsible for payment of all expenses and liabilities associated with the marital home, including without limitation any mortgage, interest, principal, real estate taxes, municipal assessments. And then it's also specifically set forth on page 28 at the top. Husband shall be solely responsible to pay the outstanding second mortgage or home equity line of credit out of his proceeds derived from the sale of the home. So the agreement said that he was responsible for, and this was put on his side of the balance sheet of the assets, and I'll explain how I know that in a minute, for this home equity line, which was the source of the funds to pay this person. So the question was, how much of that's going to get paid back, if any, and is that person going to pay any interest, which he was required to do? Therefore, the agreement said that basically, if there's any money paid in excess of the home equity line, the parties are going to split it.
Where does the word excess?
Well, it says after tax.
Where does it say that?
It doesn't say that. That's the problem. I mean,
Right.
it says after tax net payment. There's no tax on repayment of principal. So it couldn't be referring to the principal. In addition, the whole purpose of the separation agreement, which the court has reviewed and goes into great detail, was to evenly divide the parties' assets. And that's discerned from the same page, page 31 of the separation agreement. On the top, D1, division of retirement assets, monetary assets, in order to divide equally the parties' retirement and monetary assets. He was going to transfer, her husband was going to transfer $52,000 of his pension or retirement benefits to the wife. So the whole purpose of all this detail about these finances was to equalize the parties' assets. He had that on his side of the balance sheet. That meant he owed it, and any money that came back was his.
So the agreement certainly could have been written to say, husband shall pay wife 50% of any net profit received from his investment in the purchase and or development of the real estate.
And yes.
But it didn't say that.
No, it didn't. And,
Okay,
and the
so
lawyer who did
maybe,
this has passed away. So.
All right. I mean, whatever. We're all sort of living with the language that was negotiated at the time.
Yes.
So, do you have any cases that construe the word payment to mean profit?
No, I don't have a case that specifically says that.
Do you know of any case that construes the phrase after-tax net payment?
No, I don't have a case that specifically construes that. We've cited cases, as you know, that say the court has to determine the party's intent by reviewing the entire agreement, and the intent was to divide the assets equally, and he owned this home equity line. If this...
I'm sorry to interrupt, but before you drill down further on specifics, I have a more 50,000-foot view question, which is this. Your argument in the brief, which may or may not control our analysis, is that the provision is ambiguous. I'm not sure you made that argument below. My reading, and I'm looking at the record appendix, volume 1, pages 75, 76 in particular, is that both parties agreed that the provision and the meaning of net after-tax payment was unambiguous. You just had different versions or different interpretations of that.
Right, yes.
So I guess that's my question. Did you make the argument before the trial court that the provision was ambiguous?
No, we said that what it meant was, and that's to the extent it was ambiguous, we said what it meant was only money paid in excess of the loan. But then again, since this court's standard of review now is de novo, the court can go into that if it so chooses.
Understood, but to the extent that your brief argues that there's an ambiguity there, we could treat that as waived, correct?
Yes, if you so chose, yes. If this is the way we're going to go going forward with this money, that means that the husband has absorbed the full amount of the investment as an asset, but he's only getting half of it back. And the wife, which said, I don't want any part of that risk, is going to benefit by half. That wasn't the intention of the parties. I mean, we can talk about all day about this, about the language here. It's not clear. It often happens. It's unfortunate when people rush to complete separation agreements. But you have to look at the common sense version or interpretation of what do you mean by tax net payment. There can't be any tax on principal. So it can only be referring to income in excess of the principal. There's nothing else it can refer to. And as I said, if the court reviews the entire separation agreement, keeping in mind what is stated at the top of page 31, they wanted to divide the assets equally, then that makes perfect sense because he bought that home equity line as his asset. I know counsel for the appellee is going to say, well, wife had a home equity line on the house in Falmouth or on the Cape that she got, but she absorbed that, but there was no investment coming back from that was used for whatever purpose she used it for. So that doesn't mean that we discount the fact that he was responsible, as the separation agreement says, for the HELOC. I know that the appellee is going to argue that there's nothing in here tying them together, but everyone knows that's what the HELOC was used for. The HELOC was obtained and used to invest in this real estate deal. That's what it was used for. It's reflected on his financial statement, I am informed, at the time of the divorce by listing it not as a debt from these real estate entities, but as a HELOC on his financial statement. That apparently was the way his lawyer wanted to describe it on the financial statement at the time of the divorce. So yes, of course, nothing appears anywhere in anyone's financial statement saying that these entities owe him a debt. It was the HELOC. By the way, just by way of background again, he has since refinanced and combined the HELOC with the first mortgage, so now the HELOC is rolled into that. So we now have all the money. We have my understanding is $179,000 after payment of attorney's fees, so the lawyer did the collection, still sitting there. And the question is whether or not the wife is entitled to half of that or not, because it's clearly well below the principal that was loaned. There's not going to be any money in excess of the principal here. There's going to be no tax consequences. There's going to be no profit made on this. It was a loss, and he bears that loss. And it would be unfair, given the language in the separation agreement and the intention of the parties, to tell him that he doesn't get all that money, that half of it goes to the wife, who didn't bear any of the risk. So we're asking the court to issue a decision, I guess clarifying or indicating exactly that to the probate court. So if anyone has any further questions?
I have a question. You're referring to the instant judgment as a clarification. In the May judgment of contempt, however, I'm reading from the judgment dated contempt filed May 2nd, is the father is guilty of contempt for failing to provide evidence of receipt of funds from South Boston Investment and one half of the funds received. How did that need clarification?
That did not need clarification. We paid that money. We also provided the accounting of the money to date.
But the payments are from the same source, correct?
Yeah, it was, yes. It's from the lawyer's IOLTA account. That's where it came from, which came from the settlement of the lawsuit, yes.
I meant the settlement, yes. So it's from the same source, the payment.
Yes.
So how would this payment, later payment, need clarification?
Well, because it seemed the judge seemed to have been limiting her decision at that time simply to the money that was in front of her. And we thought that at some point after that, we would have a more expansive decision on the entire amount of money that was coming in, if anything came in. The other problem was no one at that time was sure, it was very unclear if any more money was going to be coming in. And it seemed like a matter of just economy, just to see what was going to happen, if anything. So that's why.
Let me see if there are any further questions.
Sure.
No, thank you. Thank you for your argument.
Thank you, Your Honor.
Attorney Bentley?
Good morning, Your Honors. May it please the Court. My name is Tiffany Bentley. I represent the former wife, plaintiff in the underlying contempt matter, and appellee before you today. This is a case about former husband's ongoing refusal to comply with a clear and unambiguous, surviving and unmodifiable provision of the party separation agreement relating to asset division. I learned some new things here this morning, Your Honors. I was not aware that the payments had been made in full according to the accelerated timeline, nor that monies had actually been turned over to the former husband. I appreciate having that knowledge. I still do not have the accounting that was ordered a year and a half ago, nor do I have payment of one half of the funds that was ordered back then. Nor did former husband file a request for stay, either in this court or in the lower court. That all remains outstanding. There are several points that really cannot be contested here, Your Honors. The provision at issue references any after-tax net payment. Again, the word is payment. It is not profit. It is not income. And there's no distinction made between payments that may constitute principal or payments that may constitute income.
Let me stop you right there. Your brother says after-tax clearly means those taxes on the income from payments, not taxes on the principal balance of the payments. And he went further at argument and said it can't mean that because there is no net tax on the principal, net after tax on principal. What is your response to that?
My response to that, Your Honor, is that if there were a tax owed, which no one knew at the time this agreement was written, then those taxes would be deducted. If no tax were owed, then the payment would be made in full and 50% would be due to my client. I think there's support for that further in the same paragraph of the separation agreement, Your Honor. At the end of paragraph 6, and this is in the appendix at page 43, the end of paragraph 6, it says, husband shall provide wife with all documentation relating to the receipt of funds and the payment of taxes, if any, associated with the respective properties/investments within 30 days of the receipt of said funds. It says taxes, if any. It's quite possible, and as it turned out, no taxes were due. It's notable that what else is not referenced in that paragraph about the documentation to be provided. There's no requirement that he provide an amortization schedule or an accounting of how payments may be allocated between principal and interest. It's just flat out payments. Deduct taxes, if any, and pay over 50% of it to the former wife. Now, as discussed during the appellant's argument, the former husband was previously found to be in contempt of this very provision. Back in June of 2019, he was ordered to pay 50% of the funds he'd received at that time. We are talking about the same pot of money. We are talking about the same provision. We are talking about the same settlement. He did not appeal that judgment, nor did he argue in the underlying proceeding at that time in the first round of contempt that the provision at issue was ambiguous. There was a second round of contempt proceedings after that first finding and before the matter that brings us here. At the time of the second contempt, former husband was found not guilty because the court found at that time he had not actually received any payments because all had been deferred to payment of the counsel who had secured the settlement for him.
I had a question about that. In your view, does the phrase "any after-tax net payment" encompass a reduction for counsel's fees?
I could argue that it doesn't, Your Honor, but we haven't taken that position because my client doesn't feel that that would be equitable to stick former husband with paying all of the attorney's fees that led to the recoupment of this investment. But I agree that under the reading of the language itself, it may not allow a deduction for counsel fees.
Going back to Justice Wolohojian's question earlier today, have you seen a definition in any case law or any authority of after-tax net payment?
No, Your Honor, I think that this language is so plain and clear that it need not be interpreted. It really is not subject to various interpretations. I think that's why the case law is devoid of anything quite on point. Your Honors, my client has been in and out of court on this issue for 3.5 years now, including, as I said, still waiting for the accounting and the payment that was ordered 16 months ago in the judgment that brings us before this court. There are 3 alternative arguments spelled out in our brief, each of which leads to the same result: denial of the appeal and affirmance of the lower court's judgment. In addition, I do believe that this is a case on multiple theories that calls for an award of counsel fees for the appeal. I'll go through those issues one by one. The first argument is waiver. As I said, this argument regarding an ambiguity was not raised in either of the prior contempt proceedings or the prior contempt judgments, which really should stand as res judicata on this issue. Even if not res judicata, it actually was not properly raised during the hearing itself, as shown in the transcript. The word ambiguous is conspicuously missing from the transcript. We see that in the index attached. Instead, former husband argued in the probate court without support that the contract unambiguously means what he claims it means. So because the issue of ambiguity was not properly raised in the lower court, former husband should be precluded from relying on that argument now. Second, there really is no ambiguity, as I've already stated, in the phrase "any after-tax net payment." No reference to profit or income, no distinction between payments of principal or income, and again, the additional language that I pointed to about the documentation that was required to be provided further supports this reading of the term after-tax net payment. What former husband is really asking you to do, Your Honors, is not to resolve an ambiguity. He's asking you to create new terms that don't exist in the document and to tie together the provisions related to the former marital home and the home equity line of credit on the former marital home to the investment in these South Boston properties where no such tie exists within the document itself and no evidence has been presented, nor could evidence be presented because the issue of ambiguity wasn't raised, so extrinsic evidence doesn't come into play in this matter. I think it's important to note also that Former husband did not request an evidentiary hearing. He could have done so in the lower court and sought to pursue this ambiguity argument and introduce testimony, counsel's files, et cetera. He did not do that, and that issue now, again, should be waived and precluded. All roads lead here to a decision affirming the lower court's ruling. And in addition, as I said, this is a case that more than amply supports an award of counsel fees. This is called for both under the terms of the separation agreement itself. Page 7 of the separation agreement at Appendix 18 calls for a party in breach to indemnify the other from legal fees incurred in remedying the breach. Separate from the contractual provision, Your Honors, we would ask for double fees and interest under Chapter 211, Section 15, and Mass Rule of Appellate Procedure 25, because former husband's arguments, now carrying over more than 3 years, are devoid of legal merit. They were brought in bad faith. This has done nothing but delay my client's receipt of funds that she is very clearly entitled to. Again, he remains in contempt of the existing judgment. We have chosen not to pursue an additional contempt proceeding in the lower court, recognizing that this issue is pending before the appeals court and wanting to stop the bleeding where we can in terms of additional legal fees, but that would be our next step, Your Honors. I'd be happy to provide the court with an affidavit of the fees incurred from the time of the judgment through today's oral argument, if that would be helpful as a supplemental briefing. If Your Honors have no further questions for me, I will rest on my brief. I do see this as a very straightforward issue with plain language in the separation agreement.
Well, let me see if there are any questions for you from the panel. No, thank you. We have your argument. We have your briefs. Thank you both for your arguments. They've been helpful, as well as for your briefing, and the case is submitted. The next case is 2020 P1321 SE versus GM. Attorney DeJunius, we're ready whenever you are.
Good morning, thank you. Patty DeJunis for SE, the wife, former wife here. In 1993 and 2003, judgments entered requiring the husband to hold hundreds of thousands of dollars for the benefit of the party's child who's severely disabled and requires 24-hour supervision. He was also ordered to provide to obtain life insurance in the amount of $100,000 with the wife and daughter as the beneficiaries. He was required to prove that he was doing both things by providing end-of-year statements and trust documents, and consistently has failed to do that. There may have been some statements produced over the course of the decades, but certainly not in every, and not in the last several years. I want to start with the life insurance provision here because there's some misstatements in the husband's brief at pages 36 to 38. The topic of the missing life insurance documents was raised at the initial hearing on the motion to vacate the attachment. And the husband's attorney said, well, I've got these documents here, I'll give it to opposing counsel after court. Well, not all of the documents were turned over, as was raised in the motion for reconsideration. Specifically, there's no schedule of beneficiaries. So as it stands right now, my client has no idea where the money from the life insurance policy would go should the husband pass away. So the judge's order on the reconsideration explicitly ordered Jeffrey to produce certain documents, the husband, certain documents which he denies in his papers. But I would just refer your honors to the ruling on the motion for reconsideration where he was explicitly ordered, on or before September 30th, 2019, husband shall provide to wife a copy of the husband's trust, including any amendments and its schedule of beneficiaries. The schedule of beneficiaries has not been turned over. He's not sought a stay of that judgment. So as of today, almost 2.5 About 3 years later, he's still not in compliance with a final judgment. And
Wait, what you just read refers to a trust as opposed to an insurance policy.
Right, Your Honor, the proceeds of the insurance policy are to be paid into a trust.
Right.
The beneficiary would be the trustee. What we
Right.
don't know is who are the beneficiaries of the trust. They're supposed to be.
So that's the piece that you're missing?
Right.
You're not missing the insurance piece of it?
Right, we have the insurance, we have the
You know
trust.
that you have the schedule of beneficiaries for the insurance policy?
I don't know if we have that. I know that what's at issue is that there's no
right,
benefit. Well, I'm sorry, the beneficiary of the insurance policy is the trust.
You know that for a fact?
Yes,
Okay, so can we go back to the separation agreement?
yes.
What provision of the separation agreement do you contend has been violated with respect to the insurance policy then?
So,
Because I misunderstood. I thought you were relying on the provision of the separation agreement that said he needs to provide proof that the insurance policy is going, the beneficiary of the insurance policy is the trust.
right, and that the trust, the beneficiaries of the trust have to be the wife and daughter.
All right, so
And we
let's
don't know that right now.
I just want to know which provision of the separation agreement we're talking about.
If I could just have a moment.
And while you're thinking about that reference, I couldn't find the divorce judgment in here.
The original divorce judgment from the, I don't know right now why it's not there. It might be due to the age that we're not able to obtain it from the court file, but I don't know. I can certainly supply that to the court if we're able to locate that.
All right, well, let's see.
So
Let's
it's,
see if you can tell me which provision of the policy.
sure, it's Exhibit F.
Just the appendix page number would be helpful.
Yes. It looks like it's page 64. Wait, I apologize. It's page
wanna-
20, page 36 of the record appendix.
Okay, life insurance, yep.
Yes. So the beneficiary, paragraph 1, second sentence, of this life insurance policy shall be the trustee of the trust, which trust shall obligate the trustee to apply so much of the income and principal as necessary to meet the obligations which the husband would have had to the wife and children under the terms set forth in this agreement had the husband not died. So this provision, and then paragraph 2, it says that the wife shall be entitled upon reasonable request for reasonable proof that said life insurance in such trust are in full force and effect.
Right, so that part you're saying, though, has been complied with, paragraph 2.
I didn't hear your question, Your Honor.
I take it you're saying that paragraph 2 has been complied with, that you have received proof that the life insurance is in full force and effect.
So there is, we do have a declaration, this is in the record appendix at page 240, from Prudential Life Insurance Company, that says that the proceeds from the death will be payable to the trust, or if the trust is in effect, to the husband's estate. Well, that's a violation of the provision, because this trust is only supposed to be for the benefit of the money's supposed to go into the trust, not into the husband's estate. So I would argue that that's a violation. But as we stand right here, we don't know whether he's in compliance or not. He's not in compliance with the court's order to produce the schedule of beneficiaries, and also not in compliance with the separation agreement, which is rendered meaningless if he's allowed to withhold that information from the wife and the court.
Okay, so let's say we were to agree with you on this argument. This affects the ruling on the motion for reconsideration, is that correct?
On both, I think, because Well, certainly the reconsideration ruling where he was ordered explicitly to produce this document, which he hasn't produced. So he's in violation of that. And the underlying issue of the life insurance also came up in the, before the motion for reconsideration. And that's where the judge had mistakenly written in the ruling that the parties had agreed that he was in compliance, when in fact they were not. And so the lack of compliance was raised in the motion to reconsider. By then, some documents had been provided, but not the schedule of beneficiaries. And so without that proof, my argument is that
So
the
does all of
attachment should
this
not.
piece of it just deal with the reduction in the amount of the attachment? Okay. So I have a question about the contempt judgment. And it was the first, let me just see if I can pull up the, so I'm looking at the contempt judgment that's on page 98 of the record appendix. And let me just make sure that that is, well, you know what, I'm going to go to the one that's on 156. So, are you with me?
Almost. Okay.
And I'm looking at paragraph 1A. Which are these amounts that at that time there was a finding that the husband had neglected to pay child support / alimony, and there was an arrearage of a certain amount. What's bothering me here is that I don't know where that arrearage comes from. Is it from, because we don't have the divorce judgment in the record, so I don't know what support obligation, what payments this relates to. Can you help me?
Sure. This relates to the payment of child support, which had been paid for the daughter. It has now been modified so that those payments are no longer required, but it is in the original separation agreement, which...
Modified as of what date?
Oh, I believe sometime within the last few years, maybe 2017, 2018. So at the
Modified.
time this entered, I think the support obligations had ended, except that he was in arrears for past payments that hadn't been made.
That was prior to the homestead being declared and prior to the
Yes.
attachment?
Yes.
Okay, so he had no support order in place at the time of the homestead.
Correct.
It would be very helpful if you could file a supplemental appendix that contained the divorce judgment and anything that pertains to the support obligations, the divorce judgment and anything that pertained to the support obligations.
So that leads me to a question about the homestead. Is there any dispute here that the declaration of homestead was filed prior to the allowance of the motion for attachment?
No, it was not filed. It was, the motion for an attachment was served
Or the
on the
motion for
husband.
attachment was allowed?
Before it was allowed, yes.
Okay. I want you to assume, and I understand you're arguing that the statutory exemptions apply. I want you to assume they don't for purposes of this question. How do you prevail on that portion of your argument under my hypothetical?
Well, because it's waived. There were multiple opportunities to oppose the motion for an attachment. It was never opposed. There were no interlocutory appeal taken after 2 attachments issued, and no appeal from final judgments in 2017 and 2018.
What's the authority, though, that, I'm probably using the wrong nomenclature, and I apologize if I am, but my understanding is that a homestead, once it is filed, once the declaration's filed, is sort of self-executing it. As long as there's no outstanding liens or encumbrances, it's in effect first in line.
Right.
So what authority is there that says, well, a subsequent attachment can take the place of the homestead as first in line? That's where I don't understand your argument.
Well,
I understand your argument, but that's where I need authority for your argument.
yes, so it's, the attachments and the final judgments were appealable orders, and they weren't appealed. I think that's clear. So, I would argue that the opportunity to say to the court that this shouldn't issue because there's a homestead, that opportunity was available multiple times, and it was not taken.
Hold on, there's a difference between an argument and a legal effect, right? So,
Yes.
Person files a homestead declaration on day one. Once it's recorded with the registry, is that when the homestead declaration gets its legal effect?
I believe so, yes.
Okay, so someone then comes along and files a motion for attachment. How does that motion for attachment take priority? Even if you get that attachment as a result of it, how is it going to take a priority over the homestead?
Well, I think here, because this is a probate court, which has,
Just asking for a general proposition.
I would say that power lies within the probate court's equitable powers, and in addition to the waiver arguments. What we have here is the husband
Can you
who...
give us a case treatise authority of any sort that establishes the proposition you just stated?
That an attachment ordered by a court can...
Subsequent attachment is going to take priority over a prior recorded homestead declaration, because that's what you're arguing.
I believe that's part of my argument. I agree. That's
No,
not my...
because you see, waiver is going to depend on this. If you have a valid homestead, and the only thing you need to do to make that homestead valid is to record it, then you don't need to do anything further, so the fact that you don't do anything further is not going to constitute a waiver. Because you don't need to do anything further.
I believe that the time for the husband to have argued that was before the attachment issued and before the...
He doesn't, but if he doesn't need to argue anything, he may just make a strategic decision and say, well, like, why would I spend time and money opposing an attachment that's not going to make any difference to me?
And as a result of that decision, he has put the wife at a disadvantage where she's spent resources and money, and there's been a delay.
Okay, but you were, in theory, the way the Registry of Deeds works, once that homestead was recorded, the world was on constructive notice of it, including the wife. So I'm not sure where the disadvantage comes from.
Well, it's my understanding that to obtain an attachment or to seek one, it's not in the normal course for a title search to have been conducted. So I don't think that that's fairly attributable to the wife, the failure to do that. The husband withheld that information, allowed this litigation to go on, and then decided to finally say something when he realized that finally a real consequence was going to attach to the fact that he depleted hundreds of thousands of dollars. He has arranged this so that he's going to get away with it. The wife doesn't have a remedy. The daughter doesn't have a remedy because he sat on this information and he waited. I rely on the arguments in my brief, but I believe quite strongly that this was waived and that as a matter of the probate court's equitable powers, that there is the ability to issue the attachment without it being subordinate to the homestead.
The attachment's on the house in Dover, is that correct?
Yes.
Is there any indication in the record as to how much equity there is in the home?
Under $500,000.
And when was that home bought? Is that in the record? I couldn't see when it was that it was bought.
I don't know offhand.
Let me see if there are any further questions. All right, so I'm going to repeat that I'd like you to file the underlying divorce judgment,
Okay.
anything that modified the divorce judgment.
The 2003 modification is in the record appendix, but I will obtain the original divorce
'cause
judgment, and I apologize for it not being in there.
That's okay.
The modification judgment is at page 37 of the record appendix.
Okay. So, thank you very much for your argument. And we'll now hear from, who's going to argue for the husband?
Good morning. My name is Dan O'Leary,
Attorney O'Leary.
appearing on behalf of the appellee father, Jeffrey Merrill. With me today is Attorney Sandy Derlin.
You come here, unfortunately, with the facts that you have, but the facts are that it appears that the husband has depleted the assets of a trust designed to protect his disabled daughter.
Yes.
So that's not a great, strong position for you.
I acknowledge that, and I think
Okay.
that this particular case doesn't. Our brief does not challenge the contempt judgment, the underlying contempt judgment, and in some ways, I think it's more helpful to think about this case as a case for post-trial relief, where here the mother was acting as a creditor and my client was acting more as a debtor. And so
Let me ask you a couple questions about the homestead. A probate and family court judge has broad equitable power. Assume that the judge, and I'm not saying this happened, but assume that from the chronology of events, the judge found that the purpose of the Homestead Declaration was to frustrate the court's ability to enforce its earlier support order. Are you with me?
So far, yes, although I would quibble with it.
I know the judge didn't make that finding, but let's assume that a judge found that the timing of the filing of the homestead was designed to frustrate the court's ability to enforce its support order. Could the judge order, for example, the husband to file like a rescission of the Homestead Declaration? Would that be within the court's order authority?
No, I don't think so. And that-
Why not? What
I think it would
authority
cut-
would you have for that?
The Homestead Statute itself, Section 7 and Section 10 of Chapter 188 specifically prescribes the ways under which a homestead could be terminated or subordinated to a subsequent attachment interest.
So which section is that?
It would be Sections 7 and 10. 7 has to do with a mortgage that's executed by all parties involved, and the Section 10 involves the termination of a homestead basically through an express or the execution of a document on the record, usually in the form of a subsequent deed that extinguishes a declarant's homestead after it is duly recorded in the Registry of Deeds.
Well, Section 7 has to do with when someone dies, so that wouldn't apply here.
So, my apologies. It would be Section 10 then?
So it appears to me that the court could order lots of different things under Section 10. So, I mean, could the court, for example, order that the Homestead Declaration be dated nunc pro tunc to after the order on the contempt?
Accepting your premise, yes. However, the premise that we have to assume to arrive at this conclusion flies in the face of a persuasive authority that was handed down in the First Circuit in the Clear One Communications case. In that particular case, the federal district court, I have the citation as well, a federal district court judge held that the fact that a homestead declaration was filed in the face of pending litigation has no effect on the validity of the homestead.
I'm not actually contesting the validity of the homestead. I'm assuming that the homestead was valid, but that it was filed for a purpose to frustrate the court's ability to give effect to its prior support order?
The homestead statute itself, it's existed since 1851, and after its most recent amendment to it in 2011, homestead declarants have very broad protections under the statute that the court has articulated and used to find ways for to go out of the way to overlook procedural defects, perhaps, in the way that homestead declarations are filed for the purposes of rescuing a debtor's homestead or right to the equity guaranteed to them by the statute. So I think if a judge were to find something in equity, for example, the court would have to consider the purposes and the express language of the homestead
Sure,
statute.
a judge acting in equity is going to take everything into account, right? But my hypothetical was just if the court found that the purpose of the homestead was to frustrate the court's authority to enforce its own prior judgment. Don't you think there are certain remedies that the court could take so that the homestead wouldn't have that effect?
It would fly in the face of the homestead statute. I
The homestead's not absolute. There are lots of exceptions to it.
The language of the homestead statute is quite broad in terms of
And
what
then
it
there are
protects.
lots of exceptions.
Well, under Section 3B, there are 6.
Yeah.
2 of which were at issue in this case, but the judge found in the 8-1 memorandum of decision and order that neither one of them applied.
So when the court's order at the end cautioned the husband that there were still other avenues of relief available, correct?
Yes.
What do you see as the range of those?
The range of those would be, I believe there are 4. The first is that so long as the attachment is in place, the mother is entitled to statutory interest on the amount owed. 2, because there is an attachment subsequent to the homestead, my client is unable to secure a refinance of a mortgage if he were even wanting to pay out or if he intended to make a payout toward that outstanding balance. And 3, an attachment, there were 3, my apologies. And the third is that, this is the mother stands in a position as creditor here. The underlying financial obligation and the structure of it is not at issue. The question is really one of how does she collect? An attachment expires by operation of law 6 years after it is ordered. So this is sort of the mother sought her remedy, and in this particular case to satisfy this debt, and she must live with the consequences of it for the time being. But she still has benefits that accrue to her during this period of time.
I have a question about your motion to reduce or discharge the attachment. You make the argument in your brief that although you didn't have a statutory site, you were acting under General Law, Chapter 223, Section 114. Is that correct?
Yes.
As I read Section 114, the statute says, if upon a summary hearing of the parties, it is found that the action is one to recover for an amount which is ascertainable by calculation, and the attachment is for a larger sum than the amount of the claim in such additional amount as is reasonably necessary to include interest thereon and costs likely to be taxed in the action, the court shall reduce or dissolve the attachment. I don't see a finding in the record by the judge that you met that second requirement of Section 114, or even alleged it, frankly.
That's correct. That finding was not made.
Nor could it have been made here, could it?
Regarding the difference between the amount of the attachment and the amount of the underlying financial obligation?
Yeah.
She could have made that, or that finding could have been made. Right, the statutory finding. But the relief that was sought by the motion to vacate the attachment and the execution is really, substantively is identical to what the statute offers in terms of a remedy to a
I guess my question is, if the second portion, that second requirement of Section 114 was neither followed here nor found by the judge, how can the attachment itself, or rather the reduction in the attachment, have been made by the judge? Do you understand my question?
Yes, I do. Not following the statutory findings, the judge would have, the judge sat as a court in equity in a contempt proceeding, and
But this is a statutory provision, so her equitable finding can't trump the statute.
correct.
Is that a problem?
Well, at least it's a problem for you when you're saying that the decision to reduce the attachment was made pursuant to this statute.
Yes, it is, and
Okay.
yeah, and there are potentially other avenues that could have that could provide a basis for the judge to have done what she, or to enter this order under Rule 60.
Was there
but we
proof
didn't
of
get into that.
where in the record was the proof of the beneficiaries of the trust?
Proof of the beneficiaries of the trust. So it would be in the, I believe my brief cites to the trial transcript to the July 24th, 2019 hearing on my client's motions to vacate the attachment and execution. And I believe it's on page,
Is there a document where the trust documents and schedule of beneficiaries, where the schedule of beneficiaries placed before the court?
it's unclear based on the transcript if the actual document was exchanged in court in the
Was
face
it
of.
given to the judge? Was it evidence? If it
There
wasn't
was no evidence
evidence,
admitted at
okay,
the
so
trial.
then how could the judge determine that the schedule of beneficiaries, what the schedule of beneficiaries said?
As I say in my brief, trial counsel for my client,
Said that some documents had been given.
yes, and based on what occurred
And
and
the
what
other
transpired in
side
the
said
courtroom.
no, and the other side says no.
But the
And
court
there's
made a
no-
finding, my apologies.
Yeah, the court made a finding based on what evidence?
What she saw in the courtroom, and that's reviewable on an abuse of discretion.
All right, so you haven't put anything in here, no one's shown us that anything was given to the judge that shows the schedule of beneficiaries. And the transcript doesn't show that the judge was shown what the schedule of beneficiaries was.
So after the memorandum of decision and order was entered by the judge on August 1st, 2019, there was I believe, mother filed a motion for relief from judgment. And my trial counsel for my client filed an opposition. And included in that opposition are copies of emails between trial counsel regarding this issue.
Which,
Their emails, do the emails attach the schedule of beneficiaries?
If it's,
not in the record, not
yeah,
in
the
the record we
documents are not in
have.
the record, the emails are.
And there was a dispute, I read the emails, it looked like there was a dispute as to whether they showed the schedule of beneficiaries. In other words, I hear you that, there's stuff in the record to suggest that you claimed you provided the information. But there's also material in the record where that's disputed, and we don't have a way of knowing how the judge made the finding.
Mhm.
Do you see the problem?
I do.
Okay. So how are we going to overcome that it looks like the judge may have made a finding based on no actual evidence in front of her?
I can't say, I can't say if the exchange was made in the courtroom at the 724 hearing. Frankly, I don't know.
I think it's a tricky one. I appreciate your candor. Let me see if there are any other questions.
All right.
We have your brief,
Yes.
and we appreciate the argument on both sides. It's an interesting and tricky case, and the case is submitted.
Thank you, Your Honor.
Thank you. All right, the next case is 2022 P0135, MM versus AM, and Attorney Zwicker Young, or do you just go by one component or another of those two names?
Attorney Young is fine, Your Honor.
Attorney Young, okay, thank you.
May I proceed?
Yes, we're ready whenever you are.
Thank you, Your Honor, and good morning, Your Honors. May it please the Court, my name is Attorney Kirsten Zwicker Young, and I represent the appellant, the wife and the defendant on the trial in this matter. What we are seeking from the Court in this appeal is a reversal, a refund, a reinstatement, and retroactive payment to my client, the 4 Rs. I would suggest to you that this case represents, this morning, several very straightforward grounds of appeal, focusing on the appellee's failure to meet his most basic evidentiary burden at the time of trial. The first issue is whether or not the trial court committed reversible error when it rendered a judgment in favor of the plaintiff on his complaint for modification, where the plaintiff sought reduction or termination of his alimony payments, where he offered no evidence to suggest that he was unable to continue to make those payments out of his incomes or assets at that time. The second issue is whether the trial court committed reversible error when it failed to consider assets that the plaintiff held at the time of the modification in determining whether or not the plaintiff could continue making those alimony payments. And just some very brief background. This is a long-term marriage, and the parties were divorced in February of 2018. At the time of the divorce, which was completed by a separation agreement, the plaintiff husband was ordered to pay the wife $4,506 a month in alimony payments.
Calculated in a certain way.
Calculated in a certain way, absolutely. It was calculated based upon the husband's guaranteed salary during the course of the calendar year based upon his ownership interest with the company. It was anticipated and it was outlined in the separation agreement that the sale of that company would take place at some point, and the wife's interest would either be bought out or the husband's interest would be then rolled over, one half of which, and shared with her in a particular period of time was placed on that. As you can see from the trial testimony in the modification in this case, the husband had a history of entrepreneurial employment with temporary disruptions in between ventures. What ultimately happened following the divorce in this case, within months, the husband sold his business and sought a reduction of the alimony payments at the conclusion of what he would refer to as severance.
We're well aware of the facts of this case. The judge made innumerable findings here. So for me, that begs this question. My understanding is that you are only challenging 2 of those factual findings, not rulings of law, but the factual findings. Fact finding 102 and fact finding fact 107. Am I correct?
I would say it differently, Your Honor. I'm challenging the fact that the court actually didn't make any findings relative to the husband's continued ability to pay alimony in this case.
Okay, but with specificity as to the judge's findings. You say that 102 and 107 are incorrect. So with that in mind, would you agree that her finding of fact 106 is not being challenged? That is the husband's total assets at the time of trial. You're not challenging that number?
I am not, Your Honor.
Okay, and does that number include that $300,000 plus Amex account?
Yes, it does, Your Honor. Your Honor, we believe that, Your Honors, we believe that the strongest precedence in this case here for the appellant is the Greenberg case. And an alimony payer has the burden to demonstrate that a material change in their circumstance has prevented them from meeting their current alimony obligations out of either income or assets. And again, that would be Greenberg, also citing Schuler at 368. This is, of course...
How was the alimony obligation in Schuler calculated?
How is it? I'm sorry, Your Honor?
How was the alimony figure in Schuler calculated? Was it by a formula such as this one, which was pegged to the differential between the two parties' income?
Off the top of my head, Your Honor, I do not know the answer to that question.
Right. I mean, you see, there's a difference between an agreement where where the parties agree that supporting spouse will pay $500 a month to dependent spouse, and an agreement such as here where there's a formula for calculating the alimony payment. And here, they agreed that the formula would be based on differentials in income,
Correct.
right? Not payments out of assets that were divided as part of the marital estate.
Correct.
So how do we get to your argument given the language of the agreement?
Because at the time the husband filed his complaint for modification, he wasn't employed. And the law allows that at the time of a complaint for modification, when we examine whether or not a material change in circumstance has occurred, we don't only look to the situation of whether or not somebody is employed, but we look at what assets and other income flows they may have. And I would look at the Dolan case in that regard, because the husband challenged the court's finding in Dolan, which allowed a modification, but much further down the line. And the husband in the Dolan case challenged the court, saying you should not have included or looked at the income from the assets that were divided in the divorce, citing 20853. And the court, I think, was very clear in Dolan to say, but we're not looking at those assets in terms of inputting or implementing an alimony order. We're looking to see if a material change in circumstance has occurred, and by doing that, we have to look at the assets and incomes available to a party at the time they've requested the complaint for modification. So I would suggest here, in this case, when the defendant came before the court, though he was not employed, he had nearly $1 million in assets available to him. During the course of the modification trial, it was clear and unequivocal by the plaintiff's own testimony that he could continue to make his support payments. He could continue to make all of his personal obligations for a period of up at least until 2 years. That was his own testimony. Examination of the 38 uncontested exhibits that went in at the time of trial showed that that the husband was not only paying his personal expenses, but doing so to a pretty lavish rate, paying $253,000 to a girlfriend. He he gifted her the money without a promissory note or any promise to repay. He spent $25,000 on an engagement ring, $57,000 on travel and expenses. My point being, Your Honors, that even though he was out of work, he drew upon his assets and the income from those assets to continue his lifestyle without disruption. The only thing he sought a disruption on was the support payments to his wife. So going back to your original question, Your Honor, I think it is incumbent, it is part of the analysis when someone comes before the court and they cite a change in circumstance, as the husband did in this case, the change being, I'm out of work, I have no income stream. And he actually, oddly enough, asked for an attribution. I'll get to that in a minute. But when a party comes before the court and does that, the court is allowed under Schuler, as recognized in Greenberg, to look at the assets of the parties and say, has the circumstance really changed here? Can they not make their support payments? We're not suggesting that a future support payment be set on those assets, but can it be sustained on those assets? And I would suggest that evidence here was overwhelming by the husband's own testimony that those continuing support payments were sustainable. One of the other issues brought up that was brought up in our brief, Your Honors, was with respect to the court's focus on the husband's income in this case. And there was much discussion about the income. There was reference to the assets and the value of this assets, but there was no analysis undertaken by the trial court as to how she was reconciling the fact that he was living off of those assets and pursuing no income. He was an entrepreneur by history, and he would have periods of temporary unemployment in between those particular ventures. And in fact, the husband came to the court and requested an attribution on his behalf, and the requested amount that he suggested to the trial court was $125,000. He came to court with no expert testimony. He professed to have no expert testimony and acknowledged on the record that it was a quite arbitrary number that he and his partner had come up with for a previous venture that had fallen through. The trial court...
But the judge seems to have credited that as some kind of fair income for the moment in the circumstances. Judge did not make a finding that that represented a deflated figure, or that it was a deflated figure for the purpose of avoiding his alimony obligation.
Understood, and I would agree to the extent that when the husband testified, there was nothing in the record that he said that would make it seem as though that was what he was planning, but more so that he thought it was quite arbitrary, a number that he and his partner came up with. And I appreciate the discretion that's allowed to the trial court, but there has to have limits to it. And the testimony, the fact that the testimony came in through by a sentence or two by the husband with that kind of backing that it was quite arbitrary, I think lacks a rational basis for the court to rely on that finding in the face of the overwhelming evidence to suggest that the husband's employment income and history had him earning in excess of $250,000, upwards of $450,000 throughout the years.
But didn't the judge appear to recognize that that amount may go up when she required the exchange of annual information about the parties' respective incomes and essentially invited people to come back if there were further changes?
I would agree with that. There was suggestion on her findings that she was thinking of that. But I would also say that this issue of the attribution of income and her attributing that amount is secondary to the more overwhelming piece of our appeal, which is that she shouldn't even get to that process because the husband was unable to make his burden of proof that both there was a change in circumstance and that he could no longer sustain his alimony obligations at the time of the complaint for modification, given the totality of all of his circumstances, not only his assets, but the way his lifestyle was proceeding without disruption.
Judgment entered on October 20th, 2021, is my understanding.
That is correct.
Was the information that the judge required to be provided annually provided? Has there been an update on that information?
But between the parties since that time?
Yes.
There was a retroactive payment made by wife to husband. I don't know off the top of my head whether or not they have been exchanging documents.
Okay, but my understanding is the judge required that the husband provide to wife his annual income, his financial. Has that information been provided as required by the judge's order?
You are correct. That is part of the order, Your Honors. I am not aware of any disruption in that order, but I wouldn't want to venture and say that I'm assured that it has occurred. Your Honors, we would close with indicating that the lower court abused its discretion in granting the modification judgment because husband did not satisfy his most basic threshold burden of establishing that a material change in his circumstance prevented him from meeting his current alimony obligations out of incomes and assets. At the time the husband signed the separation agreement, he indicated he would pay $4,506 a month. He fully anticipated that his business would be sold, and conversely, that was the basis of his complaint for modification, that his business had sold, that was the change in circumstance, although it was completely anticipated in the separation agreement signed by the parties. He testified at trial that his entrepreneurial employment had often experienced for him a history of temporary employment disruption. He testified at the time of trial that he wasn't looking for any particular traditional employment. He was taking his time looking for the best and next business venture. He went ahead with his lifestyle without disruption. He spent quite lavishly. After purchasing the home, he installed a home sauna. This was all in the trial testimony. He installed a TV with a stereo sound system. He installed a generator. These are not necessary expenses. At no point in time, and I would reflect on this, that I understand my brother counsel in the appellee's brief seems to suggest that we are proffering the notion that the husband in this case had to run down his assets and be completely depleted of any income before he was entitled for a complaint for modification. That is not so. What we are saying here is there is black letter law to say that there are two components when someone comes before the court and seeks a reduction of support. And it's not just to show a change in circumstance, but to show that they can no longer pay. And in this case, husband failed to do that. The court made the indication on page 8 of her findings, and there was the header that the husband's financial circumstance and ability to pay. But despite that header, and that was referenced in the appellee's brief as well, despite that header, you go through the 60-some-odd findings made by the court, and nowhere does the court make that seminal finding that husband had the inability to pay in this case. And I would also point out, and I'm probably going to get the initials wrong, it was the 128 decision I referenced, VW versus VW, where the court had sent back to the trial court that matter when the husband had suffered a heart attack and certainly had demonstrated a circumstance that had changed his circumstance, if you will, but not. There was no evidence in that case to suggest that that circumstance, that change of circumstance, had created an inability for him to continue to pay his support payments. As we have cited, Your Honors, in our brief, I think our strongest cases here certainly is Greenberg, where we have a retired doctor who came before the court, and the judgment for the reduction that was allowed by the trial court was reversed because although the husband had retired in that case and his income stream had been reduced, his asset stream demonstrated that he clearly had the ability to continue making those support payments, and as a result, the appeals court reversed the trial court's decision there. And it's quoting at page 348, "It was unchallenged evidence that the payor was able to meet his alimony obligations from income from retirement or investment assets without affecting his standard of living. The fact that he was retired was not sufficient basis to reduce the alimony award, especially when the wife's needs had not changed, as they have not in this case."
Let me see if there are any further questions. Thank you. We have your argument.
Thank you, Your Honors.
Attorney Platt?
Good morning, Your Honors, and may it please the Court. Attorney Nicholas Plant on behalf of the husband. I would submit to the Court that the lower court did not err when it produced a complete, thorough, and what the single justice termed thoughtful decision with respect to the issues raised in the husband's complaint for modification. From our perspective...
In your view, does the single justice's decision have any binding effect on
No
this?
binding effect.
It does not. So let's just set that to the side.
The fundamental issue at hand is that the wife disagrees with the lower court's decision. And the difference as to what the lower court has to consider versus what the lower court is allowed to consider versus what the lower court has to do versus what the lower court is allowed to do. And I think those things are getting conflated here by my sister's argument. The first piece of it is that the wife argues that Dolan requires a finding that if the husband has an ability to pay, he's not entitled to a modification. That's plainly wrong. That's not the standard. Repeatedly articulated throughout Dolan is that the standard for a complaint for modification is a material and substantial change in circumstance, the long-held standard. That standard remains in effect today, and the judge properly analyzed the decision under that framework. What Dolan stands for...
Well, doesn't materiality... There can be a big change in circumstance, but it may not be material unless it affects a party's ability to comply with a certain portion of the order. I think that's what material means.
I would agree with that, Your Honor.
And if I understand the wife's argument, it's that, sure, there was a change in circumstance. He's voluntarily unemployed at the moment, or underemployed, or at least was for a period. Now he's back into his new venture. But it's not material to the question of whether his alimony should be reduced because he remains fully capable of paying the alimony.
I don't think that's the standard within Dolan, though, applying material and substantial change in circumstance. The Dolan case was the same case. A gentleman sold his business. He received a salary. The judge lowered the support. Exactly the same as here. All the Dolan court did, the judge in Dolan did, was defer that reduction until essentially the final payments for the buyout of the business came through. And in that circumstance, this court said, the judge can look at the totality of the circumstances in setting the date, but didn't say she was wrong to lower the alimony because
Did the husband in Dolan continue to have the ability to pay the full amount?
He continued to have the ability, well, the judge found that he continued to have the ability to pay based on the earnings or the income he was receiving from the sale, and then concluded that there was a change in circumstance and reduced the alimony moving forward.
And what was the alimony provision in that case? In other words, how was alimony calculated there?
I don't know that Dolan had the same formula laid out in its underlying separation agreement as this
Did
one
the judge in Dolan make a finding as to the wife's need? Because here we do.
We do. We have a finding on
We have a
everything.
finding that the wife continues to need support,
That's right.
and the amount of support that the judge ends up providing her falls below her expenses. Do you have a case where we've affirmed a reduction of alimony where the supporting spouse continues to have the ability to pay and the recipient spouse is required to receive less than necessary for her support?
I don't know that I have a case necessarily on point that would have that holding. But what I would say is that part of Pierce is that there needs to be a fair sacrifice between the parties, that the judges, I think trial judges are often confronted with that very problem, where there in certain circumstances isn't going to be enough money to go around. And the question...
Is that in the context of a modification?
I think so, Your Honor.
Okay, so there's no finding here that he doesn't have the money to go around. He has the money to go around.
Well, I think there is a finding with respect to that, and I think she lays them out in finding 77, 102, 103, 105, 107, and 108. She talks about what his assets are. She talks about that he'll have to continue to draw down if he continues to pay. She talks about the purchases that my sister references, the engagement ring. She talks about the gift to the girlfriend, which is in fact an equity, and I further clarified some of those purchases on page 9 of my brief. The gift to the girlfriend becomes and forms part of the equity in the house that is included in the gentleman's net worth of about approximately $1 million. She makes a finding that at the time of the trial, the wife is worth substantially more than the gentleman. She's worth 1.6, he's worth approximately 1 million. A little bit more if you include all the equity, although he owns it with the second wife.
I understand all of that, but the judge doesn't find that he has an inability to continue to pay in the amount that he agreed to.
Well, I think in one of the findings
Okay, why
between...
don't you tell me specifically where?
She makes a finding that he'll have to continue to draw down.
Sure, but that's not an inability, it just has to draw down.
Fair enough, Judge. Except that I don't know that she has to make a finding that he doesn't have the ability to pay when she's concluded, looked at the totality of the financial circumstances and concluded there's been a change in circumstance.
Okay, but if he doesn't, right, but it may not be material, because we went over this before.
But I think
it may
she-
not be material, right? There can be lots of changes in circumstances, but they may not be material unless they affect a party's ability to comply with a previous order. So absent a finding of inability to pay, what makes the change in circumstances here material?
I think what makes it material is that he's lost his job, he's lost his income, he has spent down his assets, and she has considered all of that. And it's an abuse of discretion case. So the question is her decision plainly wrong, or is it contrary to the facts or the evidence that was presented to her? And I don't know how we reach that conclusion when she has considered all of the factors that she is required to consider. Whether a different judge applying the factors would get to a different result is a fair question. But this is the result this judge got to, hearing the evidence and applying every single thing that she's mandated to consider. And I would say it goes to the question really raised in Schuler, the second part of Schuler. Because Schuler, the wife likes part of it, but she doesn't like the other part of it, which says essentially that somebody is not required to draw down all of their assets to satisfy an alimony obligation. And the judge notes that at the time of the decision, he's down to $67,000 in liquid assets. And my sister suggests that the judge that he doesn't need to bankrupt himself. But when then is the modification appropriate if it's not when he has no assets left? He's drawing them down. She's worth more than him. She considers all of that. She considers the discretionary spending, and she puts it in context, which I think is quite different than the way the wife presents it in her brief. She considers all of the cases the wife relies on in her detailed conclusions of law. She considers Dolan, she considers Schuler, she considers Katz, she considers them all.
Did your client provide the financial disclosures that were ordered?
I don't know, Judge. I have the benefit of only being appellate counsel, so I haven't done anything other than the brief. I'm not sure whether they have exchanged them or not, but I would say, leading into that piece, well, before I lead into that, let me also say, she also considers every single 208 Section 34 factor that is required under the alimony statute. And she does it, starting at Section 6. She goes through the length of the marriage, the health of the parties, she goes through their station, she goes through their amount and sources of income, she goes through their vocational skills, she goes through their estate, their liabilities, she goes through the needs, she goes through their opportunity, she goes through their contributions, she goes through their circumstances at the time of the judgment, she goes through their present circumstances, she goes through it all. And then she puts a requirement on him that he has to provide this information every year so that if there is a change, the wife may take advantage of that. How that could not be a fair balancing of the sacrifice that Pierce requires, I can't possibly understand, or how it could possibly be an abuse of discretion rising to that high standard when she has considered everything, I struggle with as well. With respect to the attribution of income, Marcos makes very clear that you are required to present expert testimony to a trial court if you intend to raise an attribution of income argument. The wife doesn't present any expert testimony here. So the judge was confronted with either no salary or the husband's proffered salary. She went with the husband's proffered salary to create an alimony obligation. She didn't terminate the alimony. But in the face of no expert testimony, the argument could be made, pursuant to Marcos, she shouldn't have attributed salary, but she did. So I don't know how we can complain about her attribution of income when we haven't produced the expert testimony that the court is required, mandated to. And again, that's a mandate, not a discretionary factor like these things are, like Dolan. I think this case is exactly Dolan's case. I think that they're to the facts, to the law, to the circumstances of the parties. This case is most similar to Dolan, and it relies heavily, I think, on the footnote in Schuler, note 4, that says he does not have to spend all of his assets down. And again, I would say, wrapping up my time, that the issue really comes down to balancing out the equation that was put in the separation agreement. So the alimony is formulated based on an income. It's not formulated based on an asset pool. It's not formulated, it's formulated
Has
based.
the burden, he sought the modification, correct?
Correct.
So the husband had the burden to establish a material change in circumstance.
And the judge concludes that he does.
I know that, but it's his burden.
Yes.
So unless he establishes that, doesn't really matter the balancing of equities in terms of what the new number should be. Because if he doesn't get over the threshold, that's the argument that they're making. Didn't get over the threshold requirement because although there's a change in circumstance, it's not material because he remains able to pay at the pre-existing level.
I would say two things. I would say that I think they rely on the wrong threshold, which is this ability to pay as the fundamental legal principle with respect to the modification, and I think it is the substantial and material change in circumstance. And the determiner of the substantial and material change of circumstance is the trial judge. And unless we can say she's plainly wrong, or unless we can say that her decision falls outside of the evidence or contrary to legal principles, she's not wrong. And in
Do you
Dolan,
have any case that says whether materiality, as used in the phrase material change in circumstances, is a question of law or a question of fact?
I don't have any case on that, except that I would say that Dolan affirmed the decision to modify based on the sale of a business and affirmed the ability of the judge to determine the start date of the modification. So if in Dolan the court sustained an ability to modify based on the sale of a business and a reduction in income and affirmed the ability of the trial court judge to pick the date as long as it was rationally related to the evidence, I would say that the court would have to affirm the case at bar because the judges followed that. And I would go on to say, while my sister says they don't intend to bankrupt the gentleman, when would the modification be appropriately filed? Under what standard, if as long as he has an asset, a payor has to pay? That's expressly what Schuler tells us not to do. And I would submit that the note in Schuler, note 4 that says that, is to caution against this very circumstance, where somebody who does have some assets, and at this point less assets than the wife, is not forced to liquidate all of them before the probate court judge has the authority to modify the order. And so I would suggest that looking at Dolan and looking at the note in Schuler, we can't say that the judge is outside of her reasonable discretion in the entrance of this order.
So is materiality a mixed question of law and fact then?
It probably is, because I think what's material in one case is going to be very different in another case. I think what's substantial in one case is going to be different in another case. I think it relates to the parties. These parties were both, had significant assets. These parties had decent incomes. It was a big alimony order. But the judge does conclude that at the time she enters, the time the trial starts, he's down to $67,000 in liquid assets. If he has to start invading other assets, there's going to be other penalties and taxes associated with it. So we're talking about a period of just a certain number of months before he is going to be in a place where he has no further ability without invading assets with consequences. And I would suggest that's the position that Schuler cautions against. And unless there are any other questions, I can give back my 53 seconds.
Thank you. Thank you both for your able argument. And the case is submitted. And that is the end of our sitting this morning, so the court is in recess.